Let's tell you about the Senzomeyiwa murder trial, where the defense has suffered a loss in a bid to have the medical records of Bongani Ntanzi, accused number 2, retracted from the proceedings after it tried to stop advocate Baloyi from re-examining the witness on its contents. The document was introduced by the defense during cross-examination of Sergeant Vusumuzi Mokhane. It was introduced by advocate Mngomezulu on behalf of accused number 1 and 2. Following this close, very intimately for us is Newzroom Africa's Mnisi. We also speak now to Mpumelelo Zikalala, who is a legal analyst, and he will help us understand in terms of the legalities around this case. But first, gentlemen, let's take a listen at this moment when the judge was delivering the verdict and why he decided to go against the state.
The application, Mr. Mngomezulu, is not acceded to. It is dismissed. But having said that, you and your colleague, you can call any witness you want. But the application to exclude this evidence, which was formally tendered in this court, is refused because it's not in the interest of justice. And this gentlemen, 5 of them, make it obvious that a right to a fair trial is ambidextrous. It's not only for the accused, it is also for the state and the public, which is represented by the state. Because there's an assumption in South Africa that Section 35(5) applies only to accused persons. No, the corollary, when you understand the law, is that what should happen in Section 35 should also happen in respect of the presentation of the case of the state. It's not a one-way traffic, as they say.
I beg your pardon. Of course, that application was made by the defense and not the state. Mnisi, you've been following the case very intimately for us, and there's been a number of events that happened, especially where Sergeant Mokhane is concerned. He brought forth a concern as well that some of the accused have had sight of very private and privy information only for the eyes of the defense counsels, more so the state. And then you have this application that was dismissed. Give us some background in terms of how we got to that moment.
All right, so you remember, in particularly when you look at the issue around those confidential documents, it comes from the evidence that was given around what happened on the 18th of June 2020. That's when Bongani Ntanzi was taken to the mine to confirm what would have been his alibi, right? So you'd recall he was asked about where he was on the day that Senzomeyiwa was killed, and he said he was at work. So on the 18th of June, he was then taken to Sibanye Stillwaters, where he was employed, to confirm whether his version of events was true. And after confirming that, they were sitting with many hours that were unaccounted for because they only took him back to his cell the following morning in the early hours of the 19th of June. And they were asked, the witness was asked, what happened? Why did you not take Bongani Ntanzi back to his cell? And he said, well, we had other cases to investigate, but also we asked Ntanzi whether we could drive around with him while we conduct these investigations. And he said, well, he didn't mind because he would get bored, in his cell. And then the judge then ordered that the witness declare or disclose those investigations that he said they were busy with, and those documents were brought yesterday. But he made a specific order in that the disclosure of those cases need to be done in a form of a note, right? So the note would only be seen by the legal representatives and the court. And yesterday the witness complaining that he had actually seen accused number 1, Musira Ukulelwa Sibia, gathering other accused persons to have sight of these confidential documents that involve murder and kidnappings and threats, that some of the accused were implicated in these cases. And he said, well, the lives of the witnesses in those cases are placed at risk. But also, number 2, that the case numbers are there, so anybody who wants, really, who has access to the police system can go and retrieve that information. So this is really putting the case in jeopardy. But most importantly, this was a violation then of a court order that had been issued the day before. And then today we're dealing with this application after that matter was dealt with, of having this document retrieved, or retracted rather, and that document relates to Bongani Ntanzi's medical records on the 22nd of June. You'll remember the version of the defense, again, is that Bongani Ntanzi was assaulted from the 16th of June when he was arrested to the 24th of June. Now, in between those dates, the 22nd of June, he's then, the medical report rather, is given to the police to confirm whether or not he had a gold tooth. So why that is important is because it was introduced, this document was introduced by the defense, who said that Bongani Ntanzi on that particular day was not taken to court. He in fact was taken to the doctor to confirm that he had no gold tooth, and that evidence was led by the defense. But they now come back and say they want that document to be retracted because now the state was leading evidence on its contents, and they believe that this is new evidence, and in order to lead new evidence, you'd need to make an application to reopen your case, and that would allow the defense to cross-examine. But because they've already introduced the document, the defense themselves, they, in a way, absolve the state from proving the credibility of that document.
Mpumelelo Zikalala, did the defense not maybe overplay its hand here, but expose itself? Could this have compromised them, the whipping out of this document in terms of the report from the dentist?
It could have. Remember the narrative in which they're coming with. They're saying that we have a client who was tortured. Now, if a medical doctor is going to record on a J88, for example, or any other medical note that is there, that this particular person came to me and says nothing about any assaults that have taken place, it does dent the credibility of the line of questioning that you came about. Now, what it then does is that in your version of events, if there's something which is contrary to what has been stated, it decreases your chance of being able to succeed in that 174 application that you may want to initiate at a later stage. Maybe let's remind our viewers what that means. At the end of the state case, you do have an option as a defense to bring in a Section 174 application, which is called an application to discharge from the innocence, to say, well, we've been sitting here listening to the state giving us evidence. There's nothing which points to our clients. They haven't proven a single element. On that basis, we do not even see that we should even go to the witness box to try and prove our case. On that basis, discharge us today, and we must be deemed not guilty. Now, if there are going to be instances in which there's an element of truth or element in which the court would like to investigate further, such as this medical report, then the application may be dismissed, and the court may come back and say, go into the witness box as a witness. We want to hear your version of events, even explaining what this medical report actually means. So the defense might have shot themselves in the foot in terms of the success of the Section 174 application.
Linda Mnisi, again, the defense as well as the state, they must now go prepare heads of argument, and they indicated that they can come at 2 p.m. to do that before the judge. What is that about?
So you'll remember that there was evidence around, the fact that in the assault, particularly on the 19th of June, the state, or rather the police, diverted from the route of going to Morocco police station, and then they subsequently assaulted Bongani Ntanzi. Now, what the state was trying to do today during its re-examination was trying to counter those claims of a diversion in the routes that they used. Introducing something called an AVL. It works similarly to a GPS, which basically tracks the vehicle that they were traveling in, and according to the witness, it protects them and alerts them of any accidents or whatever situation they may be involved in. Now, it seems Advocate Baloyi managed to get the report of the AVL that basically deals with the locations and where they were. Now, the defense is objecting to the introduction of that particular evidence. Again, it says this is new evidence, and if they want to introduce this new evidence, we need to be given a chance to cross-examine on this particular evidence. It is new evidence that was not led before, but the argument of the state is that this is basically just to clear out the allegations that there was a diversion, the version that came from the defense, to prove that, in fact, there wasn't any diversion. So the court has then ordered them to prepare heads of arguments to argue on this particular point and whether or not the state can continue leading that kind of evidence.
And Mpumelelo Zikalala, this is quite crucial because Judge Ratamokgwatleng always cites the law, and he always emphasizes how he is a man of the law, whether he cites case studies, is it called case law? He cites case law, etc. And so when you take a look at this particular aspect as they're going to be arguing this afternoon, is it clear to you which way it's going to go, that indeed this will then be allowed by the judge?
I think it should depend on the manner of the arguments which are going to come in. Now, let's separate the two. If you want to testify about the route that you have taken, it's fine, you can do that. But I think the state was supposed to leave it at that. With the introduction of the report, you must then say who is the owner or the custodian of the report, who is the person that drafted it, who is the person that can be able to interpret what the report actually says. Because if you say the driver must do that, then he's simply testifying based on hearsay evidence. He's not the owner, does not know how the system works, does not know how the system can be manipulated, does not know how the integrity of the system is then protected. You are bringing in a witness who's not going to assist you in the manner of the report that you are looking for. Maybe what the state could have done would be to say, then please confirm that the routes that you have taken on that day, and then send a warning to the defense to say, we are going to be bringing in a witness or an expert who is going to interpret a report that we have given to you, who's going to have proper explanation or provide a proper explanation as to how those particular devices actually work and the accuracy of it. This type of evidence is similar to your cell phone evidence. So at the end of the day, you need to bring a person who's going to own it, an expert who then with that particular evidence, so that they're able to protect even the integrity of the evidence that is there. Introducing this type of evidence to the driver who is not owned or does not know how the system works is not going to assist you in any manner. So we may have a situation in which the judge may come back and say, yes, I can accept the evidence, just make sure that it is introduced by an individual who is going to be an expert that can be able to give me the integrity and the assurance that indeed what has been written in those particular reports is accurate.
While that is happening, Linda Mnisi, there's a new witness. Just very quickly introduce that new witness to our viewers.
All right, this witness is the driver who drove Zikalala to the pointings out. You remember on the 5th of June, he's said to have made a pointings out at a particular location that is not yet disclosed. And what he essentially was saying or telling the court was about the routes and the manner in which they got to the location of the pointings out. You remember there was a dispute around whether or not Zikalala had given the directions to this particular place. And what this witness has come and done is say that and come to corroborate the evidence that was given by Lieutenant Colonel Hadebe, who said we drove to Vosloorus, and then from Vosloorus, at the entrance of Vosloorus, Zikalala was the one that directed us to these venues. So that was essentially his evidence today.
Okay. Thank you very much to both our guests, Linda Mnisi, who is watching this case intimately for us, as well as Mpumelelo Zikalala, a legal analyst. Thank you very much.